Hello and Namaste. I am Ketan Kank from 192 Consulting. In this video, now we are going to see what happens if the company fails to comply with any of the provisions of Section 124 which we have discussed in our earlier videos. So before going into the penalty for default, let us quickly revise what we have seen earlier, what are the timelines, and what actually Section 124 states or mandates for a company to do. So the title of the Section 124 is Unpaid Dividend Account. In this, we have taken care of three timelines. First is for 30 days. The timeline of 30 days begins after the declaration of the dividend. So what it states that if the dividend remains unpaid or unclaimed by the shareholder for a period of 30 days from the date of its declaration, then the company in the next 7 days after the completion of the first 30 days has to open an account in the scheduled bank. We have seen what is scheduled bank, the bank which is mentioned in the Schedule of Banking Regulation Act. A bank account has to be opened in the scheduled bank which will be titled as unpaid dividend account. This has to be opened within 7 days. So 30 plus 7, then within the next 90 days from the amount, the transfer of the amount to unpaid dividend account, the company has to prepare a statement. That statement should contain the names, last known addresses of the shareholders and the unpaid dividend amount to that particular shareholders, which is to be transferred to the unpaid dividend account. And this statement has to be published on two websites. First is the official website of the company, and secondly, the website which is being prescribed by the central government. In my earlier video, I have mentioned that the website which is prescribed by the central government is www.mca.gov.in. Now, after the expiry of the 7 days, if the amount remains idle in the unpaid dividend account, that means it is not been claimed by any of the shareholder for 7 years from the unpaid dividend account, then that amount gets transferred to the fund which is established under Section 125(1) or subsection 1 of Section 125 of the Companies Act, which is none other than the Investor Education and Protection Fund. After that, the company has to prepare a statement as to the amount transferred and produce it to the authority which administers this fund, that is the Investor Education and Protection Fund, and that authority is called as Investor Education and Protection Fund Authority. Subsection 6, in exactly the previous video to this video, that we have seen that subsection 6 of Section 124 states that if the amount of dividend remains unclaimed for 7 consecutive years, then the shares on which that amount or the dividend has been declared will also go to the Investor Education and Protection Fund Authority. Now, this is about the provisions which actually enable the company or compel the company to do certain compliance with regard to unpaid dividend amount or unclaimed dividend account. In this video, let us see what if the company defaults on it. I'll read the section and then we will get into the simpler format of the explanation of that subsection. The default is mentioned in subsection 7 of Section 124. I'll read out the subsection. Subsection 7 states, if a company fails to comply with any of the requirements of this section, such company shall be liable to a penalty of 1 lakh rupees and in case continuing failure with a further penalty of 500 rupees for each day after the first during which such failure continues, subject to the maximum of rupees 10 lakhs, and every officer of the company who is in default shall be liable to a penalty of 25,000 rupees and in case of the continuing failure with a further penalty of 100 rupees for each day after the first during which such failure continues, subject to the maximum of rupees 2 lakhs. So the penalty, as you can see, there are two types of penalties. One is the gross amount, the one-time amount which the company has to pay, and the continuing. And secondly, the one-time amount which the officer in default has to pay, and then the continuing this thing. So the quantum of the penalty is quite heavy, and the company may also the company may also have to face the other legal consequences. This provision is something the company cannot ignore or cannot afford to ignore. So that's why it is imperative for the companies to comply with the letter and spirit of these provisions, and then it has to file the necessary returns in the prescribed forms with the Investor Education and Protection Fund Authority, which is being established under Section 125, which we will be exactly looking at in the next video, in the next Friday's video. Till the time, this is Ketan Kank signing off. Thank you so much.